Most people equate the term drug trafficking with the use of guns and large quantities of illicit drugs being exchanged for cash. But the truth of the matter is, the Florida legislature had a completely different idea when they passed the drug trafficking statute. In Florida, drug trafficking is not limited to targeting top-level drug dealers. It simply looks at the weight of the drug that a person is possessing. If that weight meets a certain threshold, they can be immediately classified as a drug trafficker under Florida law, despite the lack of any evidence to suggest they ever intended to sell the drug. It is often not until they are arrested that our clients learn that mere possession of a certain threshold weight of their drug of choice has now subjected them to harsh minimum mandatory penalties for quote-unquote trafficking in drugs. Large number of people facing drug trafficking charges got there through addiction and not through a desire to make a profit. Their threshold quantities were often reached through doctor shopping or obtaining their controlled substances through fraud. Given their addiction needs, many of our clients had little desire to part with or otherwise sell their medication. Yet, a plain reading of Florida law shows the legislature failed to consider this important distinction. The difference between a simple possession charge and a trafficking offense is often the difference between a probationary sentence versus a lengthy mandatory minimum prison term. That's because under Florida law, anyone convicted of a drug trafficking charge must serve a minimum of at least 3 years in state prison. The minimum sentence increases depending on the type and weight of the drug. There are a number of strategies our office can use in our effort to avoid prison and sidestep the minimum mandatory drug trafficking penalties. For example, can we intervene early on your behalf and convince the state to file the charge as a simple possession offense rather than as a trafficking charge by showing that you had a substance abuse problem and that you weren't motivated to make a profit? Can we challenge the admissibility of the state's evidence in your case? Is there a possibility of having your charge amended to a lesser offense that doesn't carry a minimum mandatory prison sentence? Is an entrapment defense appropriate? Could entry into a residential drug treatment program benefit your case? We are former state prosecutors and experienced criminal defense lawyers who can help. Call us for a free consultation.